Hey everybody, News Now Wyoming here with bringing you a third video of the day. This one is going to be an in-depth look at what absolute immunity actually is, and we're going to look at the case law that actually supports it. Again, I do want to state, I do not agree with this principle. I believe it is a principle created by the Supreme Court. I do not believe with any part of it. However, it is the rule that the courts must abide by. If they don't, then they're just overturned on appeal anyway. So courts have to abide by it. There's nothing they can do about that. They don't get a choice. Now, for this first part, we are going to use Wikipedia just for a brief overview. It does cite all of the different cases and everything, so please don't criticize me for using Wikipedia for the short analysis. So in United States law, absolute immunity is a type of sovereign immunity for government officials that confers complete immunity from criminal prosecution and suits for damages so long as officials are acting within the scope of their duties. I want to make sure it's clear that this is from civil liability, not criminal liability. That is one of the most common misconceptions about it. Just because you cannot sue them does not mean that they cannot be charged criminally for it. So the Supreme Court has consistently held that government officials deserve some type of immunity from lawsuit for damages, and that the common law recognizes this immunity. The court reasons that this immunity is necessary to protect public officials from excessive interference with their responsibilities and for potentially disabling threats of liability. So it says here it contrasts with qualified immunity, which applies only when certain officials, cops normally, violate clearly established constitutional rights or federal laws. So those that are actually that receive absolute immunity, lawmakers engaged in the legislative process. So you cannot sue your legislature for trying to pass a law that outlaws guns. You can sue the law, but you cannot sue the legislature. Judges acting in their judicial capacity, government prosecutors while making charging decisions, executive officers while performing adjudicative functions, the President of the United States, presidential aides who first show that the functions of their office are so sensitive as to require absolute immunity, and who then show that they were performing their functions when performing the act of the issue. That's more controversial, but that is the way it is. Witnesses while testifying in court, although they are still subject to perjury. So if I am a witness at your trial and I lie on the stand and you go to prison for 20 years, you cannot turn around and sue me for that, although I could be prosecuted if statute of limitations has not passed yet. So, and lawyers in certain circumstances related to fraud. But we're going to focus on prosecutorial immunity. We're going to ignore all those others. Those are just those that receive this absolute, again, this is absolute immunity. In 1976, the Supreme Court ruled in Imbler v. Bachman that prosecutors cannot be sued for injuries caused by their official actions during trial. For instance, a prosecutor cannot be sued for purposely withholding exculpatory evidence, even if that act results in a wrongful conviction. Absolute prosecutorial immunity also exists for acts closely related to the criminal process's judicial phase. However, they have held that prosecutors do not enjoy absolute immunity when they act as investigators by engaging in activities associated more closely with police functions. So if you act as a cop, we're going to treat you as a cop. Further, the U.S. Court of Appeals for the First Circuit recently held that a prosecutor is not entitled to absolute prosecutorial discretion when performing purely administrative functions concerning a criminal prosecution. Additionally, the Seventh Circuit has ruled that a prosecutor is not immune from liability for fabricating evidence during pre-trial investigations and then introducing that evidence at trial. So if you manufacture evidence, you're acting as a cop. Then just because you later put it into evidence does not mean that you are immune from prosecution or from a lawsuit because you are now acting as a prosecutor. You are still liable for it as a cop. And so then the qualified immunity comes into play. Was this right clearly established, or does it meet the hope standard of reaching that higher bar of this was just so horrible that anybody with their common sense would know that this is bad? So let's look at the original case here. This is Imbler versus Pachman. It was decided in 1976. Facts of the case: in 1961, Morris Hasten, a Los Angeles grocery store manager, was shot and killed during a robbery attempt. Paul Imbler was convicted of the murder after 3 eyewitnesses identified him as the gunman. After the trial, the prosecutor, Deputy District Attorney Richard Pachman, wrote to the governor of California and described newly discovered evidence that undermined the testimony of one of the witnesses. In light of the letter, Imbler challenged his incarceration in state court, where his petition was denied, and later in federal court. The federal district court found that Pachman had knowingly used false testimony during the trial and suppressed evidence favorable to Imbler, so the district court ordered Imbler's release from prison. Imbler then filed an action against Pachman in federal court under 1983, which allows a party to recover damages from any person who acts under color of state law to deprive another of a constitutional right. The district court held that Pachman was immune for civil liability for acts done in his capacity as prosecutor and dismissed the complaint. The U.S. Court of Appeals for the Ninth Circuit omitted the dismissal on appeal. Question: does a prosecutor have absolute immunity from civil liability for actions taken within the scope of his duties in bringing and pursuing a criminal prosecution? I do want you to note that this was an unanimous decision. Everybody that voted with it. Stevens stayed out of it. Yes, Justin Powell delivered the opinion for the 8-0 majority. The court held that prosecutors have the same absolute immunity under Section 1983 that they had under common law and malicious prosecution suits. In both situations, there are similar public policy concerns related to the need for prosecutorial independence. The court declined to consider whether a prosecutor was entitled to a certain level of immunity for actions taken in the role of an administrator or an investigator. Wright wrote an opinion concurring in the judgment in which he agreed that a prosecutor is absolutely immune from the knowing or reckless presentation of false testimony, but that absolute immunity should not shield claims against the prosecutor for the unconstitutional suppression of evidence. White argued that denial of immunity would encourage prosecutors to turn over more information than necessary, which would be beneficial to the judicial process overall. So why would you agree with it? Why would you vote with it, Justice White? Brennan Jr. and Marshall joined the opinion concurring in the judgment. So 3 of them said this is bad because you shouldn't be, this is bad, but at the same time we're going to vote for it anyway. Okay, stupidity. So 7th Circuit pokes a hole in prosecutorial immunity. This is just going to be an article. We're not going to look at the lawsuit itself. The 3-judge panel for the U.S. Court of Appeals, this is back in 2014. This has gone further since then to hold the same overall opinion. Policy makes it impossible to sue prosecutors who engage in misconduct, even when that misconduct results in a wrongful conviction. So we're going to skip the parts where it talks about what it is. Over the years, the Supreme Court has carved out one limited exception to absolute immunity. When prosecutors act as investigators, that is, when they engage in activities more often associated with police, they may lose some of their immunity, at which point they're only protected by the doctrine of qualified immunity given to cops and other public officials. But even that small opening isn't entirely certain. In 1993 case, Buckley, the prosecutor accused of manufacturing evidence while aiding with the police investigation, wasn't the same prosecutor who tried the case. The 7th Circuit ruled that the actual injury occurred by the defendant as a result of the misconduct occurred at trial, not during the investigation. Because the prosecutor at trial was acting in his official capacity as prosecutor, he was protected by absolute immunity. The Supreme Court took the case on appeal, but only the claims against the prosecutor who actually manufactured the evidence. So one prosecutor acted as a cop and created evidence out of nothing. And then another prosecutor took it to trial. Only the prosecutor that manufactured the evidence was held liable was held liable in a financial sense instead, and not the one that was actually prosecuting it. Another prosecutorial immunity case came along in 2019, Potawatomi. In this case, prosecutors were accused of manufacturing evidence that resulted in the convictions and long-term imprisonment of two men. The attorneys for the prosecutors accused of misconduct seized on the ambiguity in Buckley. They argued that the actual harm done to a defendant by misconduct committed during an investigation only attaches when that evidence is introduced against him at trial. And once the case makes it to trial, they argued, the prosecutor is acting as a prosecutor and not an investigator, and therefore is protected by absolute immunity. Now, I want you to think about the logic behind this argument. It's a very novel argument, isn't it? Yes, this prosecutor, McGee, manufactured evidence, and so he was acting as a cop when he manufactured this evidence. But he is immune from with prosecutorial immunity because he later used that same evidence that he manufactured against them in trial. So he can't be sued. I love the circular logic there. It was an absurd argument that would have essentially rendered the investigation exception meaningless. The only time a prosecutor could be held liable for manufacturing evidence would be if a different prosecutor then used that evidence at trial. It seemed to have some resonance with at least a few of the Supreme Court justices, but most justices seemed skeptical, and it appeared as if the court would affirm the investigation exception. But they ended up settling out of court after the oral arguments, and the case was dismissed by the Supreme Court as moot, meaning it's no longer cares. That brings us to Fields versus Wari, the recent decision from the Seventh Circuit. The case itself is a gory mess of injustice, including a trial judge who took a bribe from Fields' co-defendant. But for the purposes of this discussion, Fields discovered that prosecutors had knowingly coerced witnesses into giving false testimony, which resulted in his conviction and 17 years in prison before he was acquitted at his second trial. Writing for the majority, Judge Posner makes it clear that Buckley was a special exception in which one prosecutor replaced another before trial, and that it should not be used to close the investigation exception to absolute immunity. The act that causes an injury need be simultaneous with the injury. Indeed, it will never be exactly simultaneous for the actor to be liable. Think of products liability. We'll skip that. He who creates the defect is responsible for the injury that the defect foreseeably causes later, nor is the only harm that resulting from the conviction and the sentence. In the present case, the fabrication of evidence harmed the defendant before and not just during the trial because it was used to help indict him. Posner then explained the logic behind his own court's ruling in Buckley 20 years ago. But consider a case in which a prosecutor, whom we'll call A, acting in purely investigative role, fabricates evidence against the suspect. But the prosecution of the suspect is handled by a different prosecutor, B, who, though knowing that the evidence was fabricated, decides to use it. And suppose A has second thoughts about what he did and tells B not to use the evidence, but B goes ahead and uses it. It can be argued that A should not be regarded as having caused the use of the evidence at trial. B is protected from suit by his absolute prosecutorial immunity, thus leaving the victim of the fabricated evidence without a complete damages remedy. He would have a partial remedy against A if A's fabrication had inflicted harm against him before his trial, as causing him to be indicted. This is not such a case because Wari, the alleged fabricator of evidence against Fields, was also one of his prosecutors at trial. Prosecutor cannot retroactively immunize himself from conduct by performing his wrongdoing through introducing the fabricated evidence at trial and arguing the tort was not completed until a time at which he had acquired absolute immunity. That would create a license to lawless conduct, which the Supreme Court has said that qualified immunity is not to do. Wari's interpretation of our decision in Buckley would place that decision in conflict with the Supreme Court's Buckley decision by giving absolute immunity to investigators who have fabricated evidence, making sure that the evidence is used to convict the innocent victim of the fabrication. So, basically, you can't use that loop. You can't say, well, I was also the prosecutor, so I can't be sued. No, you were the investigator first. You created this evidence out of thin air. You were wrong, therefore you are held liable for it. Now, let's be clear. On paper, they are held liable for it, but they're not going to pay a dime. The taxpayers do. All right, then we're going to look at that other one, absolute immunity when performing purely administrative duty. So in this case, we'll just held that when a prosecutor performs purely administrative function, she does not enjoy absolute prosecutorial immunity from suits brought under 1983. Pennati was charged with drug-related offenses in November 2011. Key to his prosecution were samples analyzed at the Amherst drug lab that tested positive for controlled substances. Pennati filed to dismiss his charges after learning that Sonia Ferrick, the chemist who analyzed the samples, was prosecuted for drug use while at work in the lab. His motion was denied because of a lack of evidence as to her drug use on the dates when Pennati's samples were analyzed. In connection with prosecution of Ferrick, AG was aware of the drug treatment worksheets and a diary created by Ferrick, who revealed by her drug abuse at the lab overlapped the analysis of the samples. While these materials were used to prosecute Ferrick, she decided these records were related to Ferrick's mental health treatment and irrelevant to other criminal cases. No. Further, these records were labeled by her as assorted lab paperwork. So you mislabel what something is, and then you decide that the records themselves, well, they were just related to mental health stuff, and it has nothing to do with these other cases, even though you know you are prosecuting these other cases. Or somebody in your offices. That's important. Somebody in the office. And so Pennati filed a motion for a new trial after inspection of the evidence, prompted the head of the AG's criminal division to send them all to all DAs in late 2014. His conviction was reversed and dismissed with prejudice, and he described her conduct as fraud upon the court. I don't know if she was charged criminally. Again, prosecutor misconduct can still be charged criminally no matter what you can do against them for financial liability. And he sued, and she claimed absolute immunity as Ferrick's prosecutor. And then she appealed. They rejected the claim of absolute prosecutorial immunity, and the prosecutorial nature of an act does not spread like an ink blot, immunizing everything it touches. As applied here, her prosecutorial role in Ferrick's case does not immunize her, merely administrative role in Pennati's. Her withholding of evidence in Pennati's case was not part of her advocacy. So what they are saying here is the only thing she did in these cases was she handled the paperwork side of it. She looked over evidence and she labeled it, and then another prosecutor is the one that actually prosecuted the case. So this would be like the police misconduct part of it, right? Where if you act as a cop, you are held liable. Here, you're acting in just a purely administrative form. You are not prosecuting the actual case. Therefore, you do not qualify for prosecutorial immunity because you only did the administrative functions of it. So, that is what absolute immunity is, and why I do believe the prosecutors in the Leon Valley case are going to have their sides of it dismissed. Again, I want to reiterate, I do not agree with this. I can't call it a law, this ruling by the Supreme Court. I despise it. To use the same example I used in that video, I'll change a little bit of it for fun. But let's say I went and had an affair with the prosecutor's wife. And then, because I'm such a nice guy and I feel guilty about what I did, I then sent him pictures of us together. So he knew it was me and he knew what she did. You know, again, I would do something like that only out of guilt and not to cause him anguish or pain. And then let's say A month later, I am pulled over for my blinker being out. And the prosecutor happens to see my name on the ticket, and so he decides to review the dash cam footage from that. And he sees that, oh no, actually, not only was my blinker fluid empty, I was driving erratically, in his opinion, and so he wants to add reckless driving onto my charge. And then he also says, oh, you know what, I don't think that was a full and complete stop, so I'm going to add a stop sign to this charge, running a stop sign, and just adding charges to it, bogus charges, right? I can't go after him in a financial way for coming after me for as revenge. That is not something that I can do. I cannot go after him financially for that. I could ask the AG's office to review everything and go after him in a criminal way. I could go to the State Bar Association and go after him that way. Wyoming doesn't have a way to remove the district attorney from the voter side of things except during the election, so I couldn't hold a recall election here in Wyoming, but there's different remedies I would have, but suing him is not one of them. Because he was acting only, that wouldn't fall under that whole acting as an investigator, because all he's doing is reviewing evidence and then coming to a determination, which is very clear from the actual case itself that prosecutors are immune in their charging decisions, right? So he can review the evidence and make a charging decision and be immune from it. He wasn't manufacturing evidence. He was misinterpreting it maybe, or maybe he was interpreting it correctly. But, so, he would fall under that prosecutorial immunity. I despise this act. I do. Or not act, this, what do they call it? So, it doesn't call it anything. So I hate this decision by the courts. And I really do wish that Congress would take it up and actually write it out that no, this is not the case. Just like qualified immunity, it would take an act of Congress to remove it on a national scale. Now, a state could go in there, like Colorado got rid of qualified immunity for cases brought in on state court. Now, they can still claim qualified immunity in federal court based off of the way that the Colorado law is written, but they are immune, they can't use it in state court. A state can pass a law that says their prosecutors do not have absolute immunity in all courts, and that would probably do the trick. And I wish that Congress would pass it. I wish every state would do it, because this is bunk law. If a prosecutor, what are they afraid of? What are they afraid of? Really? I think one of the articles actually says, hold on. No. Some scholars urge courts to reconsider the scope. They insist that absolute prosecutorial immunity is not supported by either public policy or history, and that applying this doctrine in everyday situation is needlessly unworkable. Meanwhile, others push back, arguing that prosecutorial immunity is necessary to protect public servants from frivolous lawsuits. Somebody knowingly putting a lying witness on the stand is not frivolous. Somebody going out there and maliciously prosecuting somebody is not frivolous. I think this policy, I'll call it that, it's a judicial policy, does more harm than good. And I do wish that they would drop it. Thank you guys for joining me. If you enjoyed it, please make sure you hit that like and subscribe. More videos will be coming. Thank you.